Good afternoon, everyone. Harriet, are you ready?
Yes.
Thank you. Good afternoon again, everyone. My name is Harris Adams. I'm the administrative law judge assigned to hear proceeding number 23A-0197T. This matter comes on for a pre-hearing conference pursuant to decision R230455I. I'll call the conference to order, and if we can start with entries of appearance.
Good afternoon, Judge. I'm Tom Snyder. I'm with Kutak Rock, and I represent the applicant Lumen. And with me today is the company's representative, Tim Kunkelman.
Good afternoon.
Good afternoon.
Thank you.
Thor Nelson of the law firm Holland & Hart here on behalf of CCTA.
Good afternoon.
Joe Benkert on behalf of Bretza.
Good afternoon.
Tracy Oldemeyer on behalf of CCOA and LIDA.
Good afternoon.
And good afternoon, Kate Crampton, on behalf of UCA.
Good afternoon. That may be everyone. So through some informal exchanges, whether a pre-hearing conference was necessary, I think the parties after conferral asked that we get one set, and we did, and we're here. So who might I throw it off to see where the parties are at right now?
Judge, probably I might be the best one to go first, although I don't want to monopolize the conversation. So we appreciate you setting this. I apologize for some mixed communications. As you know, Lumen filed its application with the goal in mind of funding 3 routes that would be supplemented and primarily funded through federal dollars that Lumen was optimistic that it would at least receive a portion of. Unfortunately, we received none of it. And so, as you saw from our emails, because of the lack of a plan B at that point in time and the passage of time, our initial thoughts were to withdraw the application, work with the PSAPs and the interveners to put together another proposal to run for the 2024 year. We had several conversations then with counsel for the interveners, and everyone wanted to keep the momentum going, which we certainly appreciated. And so, and I'll let Tim talk about this in a second. He still is in conversations with a potential with a company that may be able to lease capacity for one of the 3 routes that we had proposed at a price point that wasn't too outrageous, at least from our perspective, if we can get it done. And so we've shared that very basic information with the interveners. We've had a couple discussions with them, and they're generally supportive of moving forward with that, obviously with the details still to be ironed out and reviewed because we haven't given them anything. And so the consensus was, and correct anybody on the call if I'm wrong, that we would come to you today, hopefully with a proposed procedural schedule in hand, focusing on one of the 3 routes that we initially had proposed, along with, I was hoping, more detailed plan that I would have distributed during this call or prior to this call for the interveners to review. We still don't have that because of some negotiations that are still continuing with the potential lessor of the facilities, and so that is causing a problem because we are all working against a clock here, a clock we're already going to need at least one waiver on. And so maybe I'll turn it over to Tim right now, maybe to give a little update on where we're at with the negotiations with the individual, if that's appropriate. I don't know.
Frankly, I don't know that I've ever had that. Let's see if we need to get there.
Okay.
First off, let's because there are timelines at play. I know the time for the project originally contemplated, we have a statutory period of time. I would like to either get a waiver of the applicable statutory period or get a procedural schedule in place that will accommodate it, the remainder of the statute. But it sounds like to me, the company doesn't want to pursue the application as it's filed at all. So I think we'd have to begin at amending the application if you so choose. So I don't know if the company's in a position to address the statutory period or not, but that's kind of the first thing that I need to work around.
I appreciate that, Judge. Yeah, I am. So we had, we were hesitant to do what would be termed an amendment to the application because we didn't want to restart applicable notice periods, and we did feel like, you know, the route that we would be pursuing in this docket is consistent with the application that we filed. We essentially would just not pursue the other two. You know, you could make a ruling that, you know, they weren't supported and otherwise weren't pursued. So we were hoping to just because of the timeframes, we were hoping not to have to file an amendment. We can if that's the requirement.
Well, I think if the application is amended to narrow the scope, but the remainder is within the original scope of the notice, it wouldn't be subject to renoticing, but it gives all the other parties notice of where the company's at and what the case you're prosecuting.
Excellent. All right, we will pursue on that fashion. And then with respect to other PUCN statutory timelines, you know, it's our understanding that we need a decision by August 1st in order to be eligible for implementing any associated surcharges by March of next year. We would be seeking a waiver for that, and I think that would be assuming we can present this proposal in an acceptable manner. I think the interveners concur with that, because I think everybody wants to start seeing this get funded and built or at least leased as quickly as possible. So that was the first rule deadline, as I understand it, that we need to address. And then there's the statutory deadline that I don't know that we can move, which I think is the commission needs to set its surcharge by October 1. Tracy and Joe, if I'm misstating the law, please feel free to jump in.
Joe Benkert here. I agree. As I understand it, it's just the regulatory deadline of July 30th to August 1st for the completion of this proceeding that would adopt the amount, the improvement amount that goes into the 911 surcharge. Since the 911 surcharge doesn't have to be adopted until October 1st, I think we could waive, if Your Honor would waive the regulatory deadline for completion of this proceeding, then we would still have some time to arrive at a stipulation and not have to put off for an entire year, starting to eliminate single points of failure in the 911 network.
Okay. Tell you what I'm going to do. I'm going to take a brief recess to confer with my advisor. And we'll be in recess for just a few minutes. I'll be back shortly. we're only missing Mr. Nelson. There we are. Okay, we'll go back on the record after a brief break. So as the parties are aware, these are relatively new rules we're applying here. And so I frankly would need to give some thought as to the August 1st deadline. I'm not sure the waiver, if of that would be part of this proceeding or the newly open proceeding. That's one thing I'd have to give some thought to. But the second thing is that still doesn't buy a whole lot of time because of the statutory deadline, October 1, as you addressed, Mr. Snyder. So, or excuse me, it may have been Mr. Binkert, but so I see a couple of options that I'll take kind of a roll call, or everybody has an option to weigh in on. We could just basically could have another pre-hearing conference in a bit of time, revisit where the parties are on a path towards the only practical resolution being a settlement. The other avenue is to adopt a procedural schedule that would be very short, resulting in a hearing in less than 30 days. And I know the parties have been working together. I don't know if there is a consensus of which of those proposals. I think as it stands right now, I've got an application, so it seems like I should do something with it. But I will hear the parties on those options or other suggestions, frankly. Mr. Snyder?
Well, thanks, Judge. I mean, I probably speak for the parties, all of them, when I express that there is frustration for sure at not having more details, and not having a formalized plan in place for costs and details associated with the remaining route, and that's not due to lack of effort on Lumen's part. It's we're relying on the third party, and so I just want to throw that out there initially. I concur with you that, and given the fact I don't have a timeline on exactly when we're going to get that formalized proposal, I think our preference would be option number one, to revisit this with the only option being a negotiated settlement at some point. We're not talking big numbers. We've shared some ballpark numbers with the interveners. Hopefully that means that the chances of not settling are smaller. But anyway, option one would be our preference. So thanks.
Roll call around the room. Any other council want to address that or disagree or want to address it further? Mr. Nelson?
Thank you, Your Honor. Just by way of maybe a mild bit of background, CCTA intervened in this proceeding in part because of the scope and breadth of Lumen's proposed approach as originally filed, and with the concerns about the potential impact that would have on the surcharge. As we have been informed through the discussions from Mr. Snyder and his client, we now understand the scope and breadth of the proposal to be more modest and the potential impacts to be much more modest. And in fairness, at this point, I've been advised by my client to simply monitor the proceeding, given the reduction in the scope of it. Having said that, we don't actually know what the scope will be. And so from CCTA's perspective, what I would ask is whatever process we have, as long as there is an opportunity to review whatever the end resulting proposal is, and to the extent my client has concerns with the impacts associated with that, an opportunity to weigh in on that, that will resolve, I think, CCTA's sort of process needs and desires. But at this point, because we don't actually know what the end result is, we just have the best guess. It's hard to know with precision exactly what to do with that, other than, as Mr. Snyder suggests, revisit this sometime down the road when more certainty is in place. But it remains theoretically possible that my client might oppose whatever it is that Lumen ultimately does, but that will entirely depend upon the details of the end result and follow, as I understand it now, with the negotiations with the other potential leasing party.
Okay, thank you. Mr. Benkert, anything to add?
Yes, this proceeding follows on from several proceedings which originated after the 2013 floods. It's now 10 years later, and we finally have an opportunity and funding to start correcting some of the limitations, single points of failure in the 911 network. And I think we will disserve all of our constituents if we don't make some progress. We've already worked out an abbreviated schedule. I don't know where that stands because of still waiting to get information. We hope to have, of course, some discovery before reaching a stipulation. My hope is to reach a stipulation and not have to spend a lot of time and when we have a very tight time limit in hearings or testimony and that sort of thing. I think the first option, if the parties can agree to, and I'm sure we can, to having some discovery and questioning after we get the plan would be our preference. Brent's preference.
Ms. Oldmeyer?
Your Honor, just to touch on a few points that have been made with respect to Mr. Snyder's comments that the parties are generally supportive of what is being contemplated. I do have to qualify that with, we haven't seen any details, and the devil's always in the details. So we were initially supportive of Lumen's proposal to withdraw this plan altogether and file a new plan in February of 2024 in light of time constraints. And so, my clients, CCOA and LEDA, have not waived any objections or any right to participate in a full and fair process to get to the end result that is ultimately proposed by Lumen. But we don't want to agree to anything that's only half-baked, where there could be alternatives that have not been vetted. We really do want the rules under the improvement plan rules to be followed in the application process. And we are encouraged by Lumen's willingness to participate in a process for purposes of a plan that will be presented in February of 2024 with advanced planning and input from stakeholders, so we can work together to hopefully a very streamlined and straightforward process that occurs on the next improvement plan. But with respect to this improvement plan and what happens here, we just don't want to be rushed, nor do we want to give the impression that this is a sure thing, because we only have oral statements about possibilities. We don't know what other options might have been available. I hear Mr. Becker's comments about the 2013 floods and we need to do something. I don't disagree from a 30,000 foot view with those comments, but if an improvement plan is put forth and approved, work can begin immediately depending upon Lumen's willingness to go out of pocket, knowing it will be reimbursed for an improved amount at some point in the future, whether that reimbursement begins in March of 2024 or March of 2025, based on the way the rules are currently written, or some variance permitted. So that's from a nutshell perspective, my client's position on this, Your Honor, and we're just kind of waiting to see what happens.
Ms. Kempton.
Judge Adams, this is Michelle Singer-Nelson on behalf of the UCA. I apologize for getting on late. I couldn't find the Zoom link, so I'm sorry I'm late. But thank you. Kate Crampton is co-counsel. And I think going back to your first two questions, the UCA is kind of in the same mindset as Mr. Nelson expressed for CCTA. Our concern, we have a twofold concern in this proceeding. Number one, we want to ensure that the surcharge isn't too high. And number two, and we want to be able to look at the cost underlying any potential increase in the surcharge. And then number two, we too agree with what Mr. Bankert expressed relating to the need to make sure we've got an adequate 911 system. But so going back to your first two proposals, whether we presume that this application will be settled and that we could keep the existing time frame, based on the conversations that we have had offline with the company and with the other parties, it does appear that the surcharge is not going to be significant, perhaps 1 to 2 cents, the surcharge increase. And then it does sound like there will be, once we do get the information from the third party, that all of us parties to this proceeding will have the opportunity to review that information and assess it and determine whether we'd be interested in a settlement. So on the settlement question, my question to you, Judge, is if we decide to go with that presumption, what if we don't settle? How would you take the process from there?
Well, I think the question is how long we wait for this settlement to materialize, because the statutory period, I understand the October deadline for inclusion in the fee to be assessed, but that's not the deadline for a decision in this application proceeding. So I think we do have some more time, or the company could choose to waive the statutory period, and if we don't get the settlement in time to lead to that October 1 deadline, assuming an August 1st waiver, be it in this case or the other case, then we would set a procedural schedule.
Okay. Well, that seems acceptable to the UCA. That approach seems acceptable to the UCA at this point in time, presuming that we do have the opportunity to review all the underlying cost data and also have the opportunity to express whether we think the cost data is reasonable.
Okay. I think I've heard from everybody there. Finally, Mr. Schneider, I know you said you don't control the time, you're waiting on a third party. What time frame are you anticipating on and knowing whether the company wants to pursue a portion of the application as filed?
Well, the answer to the second part of that question depends on the terms of the negotiation. So I think the company wants to pursue the application if we can get negotiated terms to our liking, and therefore I assume the group's liking. Tim, would you say 2 weeks would be the period where this should be wrapped up, or if we're going to go forward or not?
Yeah, I think that's a fair amount of time to know definitively if this is going to work out or not.
And to have some detail.
For sure.
Well, it's not an ideal scenario, but it keeps the case alive for the moment to do that. And so barring objection to anyone, what I think we'll do is we'll just revisit this in 2 weeks and see if we've made any progress or not. And if there's not by that time, then I think the company either chooses to withdraw the application or we set a procedural schedule and go from there. Any objections to that approach?
Your Honor, a clarification, the company can waive the August 1st deadline?
No, I'm sorry. I'm talking about, this is an application proceeding under 46-109.5. The commission has to issue a decision within 250 days of the application being deemed complete. So that is the governing deadline for this application. But I'm not suggesting the October 1 date could be waived. I'm just saying that that's a deadline. I don't think that deadline says this case is over at this point.
I guess my question is a September 1st deadline or a September 7th, just kind of a realistic deadline that would, if we get within 2 weeks of playing, that we would have that long to do discovery and work out a stipulation. Would you consider that realistic?
No, if I'm following. So either for me to issue a decision that's going to be final by October 1st, I've got to have the decision issued by September 7th. At the latest, I believe, or, not counting fingers and toes. So I think that it couldn't be as late as you suggested. I mean, I think it has to be something in the next 2 weeks. And then there'd be a very abbreviated timeline. And I'm not saying I'll do that. I think it depends on the parties.
Thank you.
Okay. While we're all together then, look at my schedule. Two weeks would be the 3rd. And in the morning, say 9 o'clock.
Judge, I have a all-day mediation on the 3rd, which anybody who goes through mediation knows involves 90% sitting around, 10% participating, but the 9 o'clock is probably the time for participating for me. If we could go a little later.
I could go as late as 10:30. Or we could back up to the afternoon of the 2nd.
I would certainly prefer the 2nd, but I could do the 3rd later if that works better for other people.
Yeah, how about the afternoon of the 2nd, say 3 o'clock?
I'm sorry, what time are we suggesting on the 2nd?
3 p.m., August 2nd.
Can you give me just a moment?
Sure.
Judge Hasenhofer, I can probably make that work. I can try to move something. Would it be at all possible to do 4 p.m. on the 2nd instead of 3? And if not, I will work to try to make that happen.
Well, just on the chances, then let's go off the record just a moment, just so Harriet's not trying to count calendars. 4 o'clock on the 2nd is okay with me. And is that a problem for anybody else?
No, Your Honor.
Then we should have stayed on the record. Okay. All right. Harriet, we'll go back on the record. Okay. Seems like the parties are available on August 2nd at 4 p.m. to hold a pre-hearing conference in this matter. And so we will recess without doing anything further. And I'll look forward to hearing the status of the case from the parties on August 2nd, and we will go from there. Anything further we need to address today?
Will that be on the same Zoom link, or will there be a new one that gets circulated?
There will be a new Zoom link.
Great. Thank you, Your Honor.
You bet.
Your Honor, just be helpful when we're off the record if we could set up to have Mr. Snyder send us a link for us to confer, just because we're all here in the limited time separately after this hearing. Would that be possible, Tom?
Yeah, you want to talk about scheduling a call with our group?
Immediately after this.
Okay, sure.
Okay. Well, with that, I think the pre-hearing conference is complete, and we'll be off the record. Thanks everybody for attending, and the parties, if you need a minute more, we'll stop the webcast. And the recording.
Hang on. There's a couple extra steps to stop the webcast now on YouTube, so give me just a second.